This is the Tea on International Arbitration with Gaela Gehring-Flores and Nicole Silver. Gaela is a partner and the global co-chair of international arbitration at Hughes Hubbard & Reed, and I am the U.S. head of operations and lead underwriter for Ignite Specialty Risk. Both of us serve as committee chairs of the DC Bar International Law Community, and today we are welcoming you to a specialty to discuss a topic that has been brewing for several months now, if not longer. And that topic is political pressure on the litigation finance industry. And alas, it seems like no industry today is safe from regulatory overreach by our government. But in all candor, this isn't exactly a new problem in the litigation finance industry, a topic of great interest to our listeners and those who work in international arbitration, has been on the receiving end of criticism and political pressure for as long as I can remember and have been working in the field. So what's happening now? Why does what is happening now feel more real and severe than before? And what are we going to do about it?
To help us investigate this evolving topic, I'm pleased to welcome our guest today. Erika Levin, a partner at Fox Rothschild, is a member of the international group and leads the firm's Latin America practice and litigation finance group. She has extensive experience in high-stakes international arbitrations and cross-border litigations, as well as enforcement and asset recovery. She's also a fellow of the Chartered Institute of Arbitrators and serves as an arbitrator in many of the leading arbitral forums. A significant segment of her practice, fun fact, is dedicated to arbitrating cases in the fashion, technology, and entertainment industries. And Stuart Grant is the co-founder and managing director of Benchwalk Advisors, one of the leading litigation funds in the world. He is also an internationally recognized business leader and litigator. Prior to starting Benchwalk, he co-founded and served as managing director of Grant and Eisenhofer, one of the most formidable plaintiff advocacy firms. Throughout his career, Stuart has been at the forefront of corporate governance and securities litigation. And while he has received countless awards and honors, one of my favorite facts about him is that he is an owner and breeder of thoroughbred racehorses. So, welcome to our esteemed guests, and let's jump right into it. Nicole, over to you.
Thanks, Gaela. So just first off, while we're directing questions to one of you specifically, please, either of you, feel free to jump in on a question if you have more to add or something different to add. And we are really hoping that this will be a very fluid and open dialogue. That said, Erika, I'm going to start with you for our first question. I know it was an eventful summer with the Tillis bill being proposed and then defeated. I was hoping you could talk us through what the proposal was and what it would likely have done to the litigation finance industry had it passed.
Sure. So I think most of us that are somewhat following the litigation finance space are now know Tillis's name. And it's interesting, just to give some context, what started out maybe before as disclosure, transparency efforts somehow morphed into attacks on litigation finance profits. So the Tillis bill, essentially what was being proposed was a tax on profits, initially 40.8%, later revised down to 31.8%. What that would have done would have been pretty much decimate the industry in the sense that there wouldn't have been any real ability to invest and be profitable in the space if that had passed. And the reason it was sort of structured that way was to get it into the One Big Beautiful Bill, right, as sort of a tax measure. The irony, though, is that sort of a tax wouldn't have actually accomplished much because you would need the industry to continue in order to receive taxes and to make money off of it, right? You know, the removal, we all know, came via the Bird Rule challenge, right? People were able to basically explain that the provision wasn't really a tax provision. I think there was a coordinated effort amongst a number of forces. I know ILFA was very much involved, but there were a lot of people that were working behind the scenes on this one. And the real importance, I think, of this was it was one of the more prominent attempts where we saw a coordination of efforts. Before that, we had had these discussions in terms of the need to coordinate, the calls to action, so to speak. I know from my perspective, having been on this scene for a long time, in the UK, there was this hope that we could self-regulate through these organizations like the ALF, the Association of Litigation Funders. And sort of the thought was with ILFA, we could also do the same thing in the US and abroad. But more and more, it became increasingly clear that there was more political questioning, pressure. Some of it, we may say, is misinformation and politicized, right? But there was more and more pressure, and there's more of a need for education and transparency on this issue. And, one thing I have to say is thank you to you, Gaela, and to the DC Bar for doing this podcast, because I think the more that we address these issues and discuss them, the better, because there is a fair amount of misinformation out there. But really, the most important thing to know is that there are attempts to regulate litigation finance. I think a lot of those attempts are somewhat misinformed because they don't fully understand what it is, right? People don't even understand the distinction between commercial litigation finance, consumer legal funding. There's lots of different iterations out there. And the key is really for us to make sure that people understand what it is we're talking about, who it helps, and to cut through the misinformation that's out there. And so, again, happy to answer any other questions, but as a broad brush, the efforts aren't only being undertaken here. It's the US, it's the States, and it's also internationally. We've been focused on the UK and Europe as well. One of the things that I thought was really daunting was when we were preparing and talking in terms of the TILIS actions, we put together a report and a presentation that showed all but a handful of states are addressing the topic. And that really also needs to sort of be acknowledged because it's not just the TILIS bill that did not pass, but there's going to be continued efforts, I think, on this front. So, I'll pause there, and I'm sure Stuart has some thoughts or you have some more questions. But really, I want to commend the industry in terms of their coordination. And I know it's not an easy undertaking, but it's really important.
Thanks, Erika. I guess just to follow up with Stuart on some of your comments, Stuart, in your opinion, what's the motivation behind the TILIS bill? And maybe more specifically, who was really pushing it, either openly or, more importantly, behind the scenes?
Sure. Let's start with the second question. It was basically being pushed by three groups: big tech, the insurance industry, and the traditional Chamber of Commerce. And we can talk about motivation. I think the motivation was that plaintiffs were having successes, particularly against big tech. And a lot of those were financed by litigation finance entities. And so these entities decided that it was in their economic interest, big tech in particular being the newest one to jump in. We're sort of used to fighting the chamber with a little help from the insurance industry. But big tech was the newest one to jump in. And they said, the way to end this success is to cut off the supply of money. But I think it's also important whenever we talk about motivation, it's sort of like a good murder mystery. You need motivation and opportunity. And to follow up on some of the things that Erika said was the big, beautiful bill is what really gave the opponents of litigation finance the opportunity. And they were very smart in seizing that opportunity and actually likely would have been successful because remember, the TILIS bill was not defeated. It was actually ruled out of order. If it went to a vote, it likely would have passed. And that was because the big, beautiful bill had this very unique circumstance where, number one, you only needed a majority in the Senate to get it through. Normally, you would need 60 votes. And number two, you couldn't deal with the bill in and of itself. It was glommed onto a much, much larger bill. And while there were a number of people who would have voted for the big, beautiful bill, if you asked them whether they wanted it out or not, there probably would have been several of those people who would have voted yes, said, I don't agree with the tax on litigation finance. But if I have to decide whether I want to vote with the party and vote with the president on the big bill itself, or oppose it just on this limited issue would not have opposed it. And so, in a way, you could have gotten a bill passed through the Senate where there might have only been 30 or 35 senators who truly supported the bill. And so it was very unique in that respect. It was also done in a very different way than the traditional attack that the Chamber of Commerce and the insurance industry has made, not only on litigation finance, but on the traditional plaintiff's bar and anything that would open up access to justice. And what those opponents did was they tried to counter the access to justice with saying, gee, it's costing every American family, I think the number they came up with is $3,500 because products are more expensive because of litigation. Now, I don't really know how they come up with that number, but the idea is let's threaten the American consumer saying life is going to be more expensive because of litigation. And by and large, people weren't buying that. And they said, no, I know what happens if I don't have access to the courts. I know what happens if I don't have ability to challenge antitrust, if I don't have ability to challenge defective products. And that makes my life much more expensive. And so the traditional plaintiff's bar, litigation finance, those who are willing to put their stake at risk in litigation were always able to defeat that. But this time, the challenge came from really understanding the feel of the country and the anti-foreigner feeling that was going on. And so it wasn't just a tax. What the proponents of the Tillis bill said was that foreigners are coming into this country and financing litigation. And it's litigation that is hurting American industry, and that is why they're doing it. And by the way, they're making lots and lots of money, and they're paying no taxes on that money. And therefore, what we have to do is we have to tax them at the highest possible tax rate, and that will level the playing field with domestic investors, and that will stop them from destroying U.S. industry. And of course, none of that was true. It really had nothing to do with whether foreigners were coming in or not. I would submit that foreign investment in litigation finance is actually quite low, that numerous entities that invest in litigation finance actually pay taxes on their profits. And to the extent that they don't, it's because of tax treaties that are already in effect. And the bizarre thing was this would tax US investors also, and it would tax US investors who invested in litigation finance in foreign jurisdictions. So none of the justifications actually made any sense, but it was an opportunity for big tech, insurance, and the Chamber of Commerce to seize on the anti-foreign feeling in the country and to try to use the big, beautiful bill as their conduit to passing something that would otherwise not have support to pass.
Thanks, Stuart. I guess just a follow-up on that, it strikes me as important big tech's entrance into this fight. And given the current administration's partnership, interest in perhaps merging with big tech, and Erika, I would love to know your views on this as well. Why do you think you were actually able to defeat the Tillis bill? Given everything that's been happening so far, it seems that if the current administration has their eye on something or their mind on something or their interests are allied with big tech, it will happen. So how do you think you were able to, at least for the moment, basically turn the tide?
Well, let me answer that briefly, and then let me kick it over to Erika. First of all, again, remember, we did not defeat the Tillis bill. We got the parliamentarian to rule that it was inappropriate to go in the big, beautiful bill. And that was the win. Absent that, it probably would have passed. The second part, which going back to my trial lawyer days, I would object to your question as assuming facts not in evidence. And that is that the administration is hand in hand with big tech. It's a very odd relationship, and I'm not sure I understand it. I'm not sure anyone understands it, of what the administration's view on big tech is. On one hand, you see, all the leaders of big tech surrounding the president. On the other hand, the antitrust actions that are being brought by this administration's Justice Department, some of the other actions that have gone on, and certainly the actions in Europe, are very much anti-big tech. And so I don't know where it is that the administration is. The administration would love to see manufacturing of chips back in this country, but where is that when it comes to the Facebooks of the world or the Googles of the world, who are not necessarily manufacturing but are service providers? So I don't know where that is. I don't know if big tech will continue the attack. I assume they will, because it's certainly in their interest to cut down on litigation against them. But I don't know if they will have that golden opportunity that they did. And certainly the industry has woken up and will not be caught off guard again. Erika, I don't know how you feel about that.
Well, let me ask this question, Erika. And I think that whatever you were about to answer, you can glom into the answer to this question. But it is interesting the reasons for which the Tillis bill went away and the reasons that it could have passed if it was part of a larger bill. So my question is, are we out of the woods? What should we be bracing for next? What should we fear? Are we concerned that there will be, another large bill into which this can be placed again, or some new iteration of this? Are we more concerned about standalone bills? And I guess, answer however you want, but what should we be bracing for next, and when? What do you think?
Sure. So, I just need to echo what Stuart was saying in terms of, I'll put it, the dodging of the bullet on Tillis and the Tillis bill in terms of the one big beautiful bill. It was due to the parliamentarian sort of aspect, the Bird Rule challenge, right? So it didn't go forward because basically the parliamentarian ruled that it would have had a negligible budget impact. In fact, it wasn't the right bill for that, right? It wasn't the right vehicle, conduit, as Stuart said. It was super creative, incredibly creative. And I agree with Stuart. I actually think in some ways, though, we need to be saying thank you for that, because it galvanized the industry in a way that I don't think our prior calls to action had done before. I think this was one of the real wake-up calls, at least on the US, grounds in federal. To your question in terms, is this it? No, we know it's not. This is just probably the beginning. In fact, I also want to make sure that we're clear that there's so much activity going on day to day around the US and the state legislatures currently. You name it, day by day, this is being addressed and discussed in the state legislatures. And so we really have to keep our eyes poised federally and state by state. And I think one of the more important things, listen, I don't know necessarily if there were other motivating factors, and if there were, great. If there weren't, there should be. Because part of the misinformation is the fact that the funding is helping the majority of the constituents of these legislators. They're receiving misinformation, and I represent the majority of funded parties, right? Law firms and or funded parties, sometimes funders, but I work in the industry in all facets. But the majority of those actions are ones that are access to justice, actions that should not be prohibited or prevented from going forward because of a lack of capital. That's just not serving justice, right? And I think that there's an idea here where there's misinformation and politicization. Stuart talked in terms of the taking advantage of the anti-foreign sort of sentiment, right? That's what I mean when I say politicization. It's grasping on to these sort of undercurrents and movements that are then used to package some sort of misinformation. And I think we need to call that out, and we need to be clear about that. I think we will continue to see efforts on various fronts, and we're continuing to do so. And if people are listening, I think the most important message I want them to hear is we need to be out ahead of this as much as we can. We've had the wake-up call, continued wake-up calls, and now we need to be ahead of it. And what I've been frustrated by, candidly, is when we see provisions, regulations, proposed legislation that doesn't make sense and it's a little too late. There shouldn't really be that happening anymore. We need to get ahead of it, because this is not that complicated, but it takes some explanation and it takes some effort. And so, I foresee we'll continue to see efforts on disclosure, right? And interestingly, we've been talking about disclosure for years now internationally, and it needs to be done in a careful way. But even going way back to when we first started looking at litigation finance, then it was called third-party funding. The nomenclature changes over time. Now it's legal finance, litigation finance. But the one issue that we really had to grapple with was, what is it? The definition. So everything's globbed in together as one, but there is differentiation. And so when we talk in terms of the measures that are coming forward, we also have to be careful about what are we trying to regulate? What does that look like, right? And what we're putting forward what will the impact be? Just really understanding the players and the effects of what we're proposing to do. It requires careful undertaking. And I would also urge to have all of the voices, as many as possible, at least in the room, so that whatever's being undertaken is thorough and analyzed carefully. Because again, it's easy to say, let's call for disclosure, but disclosure of what, how, with guardrails or without, that can lead to other issues, right? So I'll pause there, but I do think that we are not out of the woods. But luckily, I think that there has been a galvanization of sorts that was necessary, and hopefully it's continued and organized. But frankly, I think this is just the beginning.
Erika, while I agree with you about it would be nice to have everyone in the room and to think about these things, that presumes that the reason that people want to regulate litigation finance is for the greater good.
I understand.
If the idea is to cut off the enemy's supply line, then you don't have a discussion as to, the benefits of that. You just bomb the supply line. And that's what's going on here, that those who are targets of litigation don't like it.
Yep.
And if they can cut off the supply of money, there will be, in their view, fewer cases. I think the other problem is, once you have litigation finance, the people who are really challenged, not the defendants, but more the traditional contingent fee bar, because those folks now have more competition of the hourly fee bar, because we can create synthetic contingent fees to allow both hourly firms and contingent fee firms to look at taking this work. And, all of a sudden, the Am Law 250 is happy to line up taking plaintiff side cases and going against, big tech or other more traditional defendants. And I don't think they like that part of it either. So if I thought that people were actually approaching this in good faith, then I would be very supportive of sitting down and trying to provide information. But I see little indication that regulation is in good faith, but the regulation is being used to do what the current administration says regulation is used for, which is just to, crush industries. And that if we remove regulation and let the market and industries take care of things, life will be better off and America will be great again. And that seems to work for certain industries that are chosen ones, but maybe not so much for other industries.
Yeah, that may be a somewhat inconsistent approach. No, I couldn't agree more. And let me say this. If there are attempts to regulate an industry, the members of that industry should be involved and should have a voice in some way. So I understand what's happening. I mean, at the end of the day, the interesting aspect is, you identified it beautifully. There's a lot of different factions and there's a lot of competing interests, right? And without this source of capital, those who have breached, let's not forget, you don't have any of this occurring unless there's been a breach. The idea, though, is that without this, their breach goes unanswered. And sure, if you can somehow figure out a way to avoid that, they're going to try, right? But I think in all honesty, that's not the way the system should be working. And you bring a really interesting point in terms of the legal field, right? The plaintiff's bar, traditional plaintiff's bar, contingency bar, and then this mixing of the Am laws, right? Litigation finance, from a pure business of law perspective, has really changed the playing field. You're right, there's more competition, and there's also more scrutiny, right? All of a sudden, There's a lot more attention on these types of cases. And this is what I was referring to in terms of the nomenclature, the definition. There's ways to parse out contingency from legal funding and not. Look at the definitions if you're going through these various attempts to regulate, and you'll see some will encompass the traditional contingency plaintiff's bar and others won't. And the main distinction is it being self-funded by the law firm or not? Is there money coming in? Is there independent money coming in? So there's a lot of nuance here. And I think the most important aspect, though, that we really need to focus on is who is trying to accomplish what and why. And for whatever reason, pointing the finger at the big bad funder, that's just not accurate. And so I think the more that we're able to be involved in terms of correcting that misinformation. And also, I think one of the challenges has been putting forward suggestions could lock us into a position or lock people into a position that might not be comfortable, but there needs to be some sort of involvement. Otherwise, we're left with attempts to regulate and control that don't make sense. And you're right, there won't be a legitimate, genuine discussion or discourse if someone's trying to take advantage of the political system in a certain way. We all understand business. We understand how it works, why it works. But I will say there's an aspect here where if there are actions that are meritorious, I guess this was sort of what we faced in the beginning of the industry when I first got involved. This idea that somehow litigation finance was spurring unmeritorious suits. Let's not forget those that are getting involved are investing. And actually, I would say they say no more, way more than they say yes. And so really, it's a vehicle for allowing people to bring cases and access justice in a way that perhaps they wouldn't have been able to do either as efficiently or with the team that they have. It does allow better advocacy. It allows different teams. And I will say this, I've seen firms who were straight contingency at one point and were not necessarily understanding of third-party funding litigation finance a decade ago, changing and using litigation finance in various ways. So those that have been understanding and adapting are using it, and you're seeing it. It may not be broadcast, but I think this is a topic of discussion and or analysis for most law firms, whatever the size. It may have been used initially by boutiques and or maybe smaller firms, medium-sized firms, but now all sizes of firms are exploring litigation finance. So it's definitely a broader play.
Now, Stuart, you mentioned synthetic contingency fee arrangements, which would, as I understand it, allow hourly based traditional AM law firms to essentially convert their representation to kind of a contingency fee model, but having their legal fees being funded. Would the Tillis bill not affect something like that? You know, would its tentacles not reach into the profits of a litigation funder that set up this synthetic contingency arrangement?
Yes, I think it would have.
Oh, okay.
I think it would have. Yeah. So look, at the same time that we were fighting the Tillis bill, there were the creative, sort of corporate side lawyers or structuring lawyers who were trying to figure out, okay, let's say it comes into effect. How do we work around it? Do we set up offshore funds for our foreign investors and we will just invest in, a foreign litigation? Because a firm like ours, I mean, we're global. We're only slightly more than half in the US. I think we're about 48% outside the US. So should we take our foreign investors, put them in a foreign entity, run it out of Guernsey, and just invest their money in those things, and then we stay away from Tillis and we keep our domestics domestically? And do we try to set up other structures, instead of lending to a law firm and having the security of a single case or a portfolio? Do we make it, a recourse loan to the law firm against, more than that? And, there's some question. Then they had some silly thing in there where you can tell it wasn't well thought out that, any loan that's more than 7% interest falls under litigation funding at a time that, effectively the risk-free rate was close to 6%. So, all of a sudden, we started talking to large firms who don't necessarily use litigation funding, but do have credit lines, and their credit lines, were all of a sudden 8%. It was like, okay, are you, now going to fit under this new tax? But the funny thing was that if the Tillis bill passed and we managed to invest domestically, a lot of our investors were already paying capital gains at 23%. And so all we were talking about is adding another 8% to it. And all that means is the price of litigation funding is going up. And so there will be fewer cases funded, but the bigger ones will get funded. It'll cost more, and we will still get, a return. So I don't know that it would have wiped out the industry, because there was still a lot of demand and a lot of opportunity to make money, but it would have wound up being way more costly to the users of litigation funding. And the question is, is there a social good to that? I'm not sure there would have been. And so it raised a lot of questions. It would have been generally bad for the industry. I'm not sure it would have wiped the industry out, because there are some creative folks around.
Yeah. And I know that you've certainly covered some of the more problematic aspects of misinformation, disinformation, circulating around, criticisms, if you can even call it that, of litigation finance. Certainly it sounds like there are xenophobic elements, and then just plain false information as to whether or not, who is actually funding these. Are people foreign? Just even how it works and who it benefits and who it doesn't. But in the broader scope, even beyond the Tillis bill, as we know, there have been, plenty of criticisms of the, dispute funding or litigation funding industry for quite some time, and certainly in the international space. Just thinking generally of all of the criticisms that have been leveled against the industry, what do you see as the most problematic, toxic, or unfounded claims that have been leveled against litigation finance?
I don't look at it as the toxic things, because that's usually one-off, something really stupid and crazy that's either happened or somebody says. The real thing that has been done is the big lie. And that's what you need anytime you want to sort of crucify an industry, a person, whatever. You got to come up with a big lie. You've got to make them evil. And in this instance, the big lie is that litigation financing promotes the bringing of frivolous litigation. And frivolous litigation costs each of us thousands of dollars. And so you need to convince Joe Sixpack that litigation finance is what's hurting him. He'd be able to take his next vacation if only he had that extra money that has just been pissed away because people have been bringing frivolous litigation. And of course, you just got to repeat that lie over and over and over again so people sort of accept it. And, you throw nice figures. So you think there's some research, it's $3,500, a family, according to, the Chamber of Commerce. Well, hey, that's a reliable source. But when you come back and think about it, you say, well, wait a minute. We have investors and lots of big institutional investors who are giving us a lot of money. And we turn around and we invest in litigations. Why would we invest in frivolous litigation? Frivolous litigation presumably will lose. And why would we want to do that? Because if we lose our investors' money, first of all, we don't get paid, and they won't continue to invest in us. So where is the logic? And in fact, I think Erika brought this up. If you were designing a system of litigation, you would love a gatekeeper. And if someone funds themselves, there is no gatekeeper. They can say, I want my pound of flesh. I'm going to go bring this litigation. We don't fund people who want a pound of flesh. We don't fund people who want to prove a point. We fund meritorious litigation that is going to make an economic, rational recovery so that we can get paid. And so, in a way, we wind up fulfilling the role as a gatekeeper. And we turn down 94% of the cases we see. We take only 6% from the time we first see them that make it all the way through the funnel. And so what that is telling you is, gee, if we're willing to fund your case, you now have an outside third party who's willing to put their money where their mouth is to tell you that this is a good case. Now, are we always right? No. Are we right an overwhelming majority of the time? Yes. And it's not because someone says, oh, well, Benchmark is funding. Let me just roll over and pay them a lot of money, even though this is a frivolous case. It's because we have spent weeks looking at a case, digging in, doing the research and saying, yes, this makes sense. And so we've also had instances where we've turned law firms down who brought us stuff, pointed out the holes in it, and actually had them come back to us and say, you know what, we decided not to bring the case. So we really do the exact opposite of what we're accused of doing. Is we actually are a gatekeeper, not someone who's funding frivolous litigation, not because we're terrific and wonderful people, but it makes no economic sense for us to fund frivolous cases. And that's why we hire and we have staffs to weed out frivolous cases. That's the big lie that's told over and over again, the axiom that you have to believe in order to say, and therefore we need to regulate, we need to tax, we need to disclose, we need to do all these things to litigation finance. When the reality is you don't. Now, that's not to say every once in a while, and I don't know all the facts on it, but you hear a litigation funder, one in particular who might be public, stepping in and saying, gee, we actually want control of cases and we want to make decisions. But there's actually already laws and rules about that. They just need to be enforced. It doesn't need additional regulation. And we know as a litigation funder that we're providing capital, that it is the lawyers who still have to provide their judgment and practice law, and it's the clients who have the authority to resolve or settle a case or not. Now, that doesn't mean that we're not part of the team and we don't give our opinion, and we think that we're valued, and we try to only get involved in cases where people think that we add some benefit. I've tried an awful lot of cases, and I think that the smart law firms who fund with us say, gee, there's a free resource who used to charge a couple $1,000s an hour, and now we can pick his brain for nothing. So I think there are those benefits, but I think on the very limited instances where a funder oversteps, I think there are existing rules and regulations and laws. So I don't actually see the regulation of the industry as a high priority, because I think the economics are what's really regulating it if you look closely. But that doesn't help the people who would like to kill access to justice, and so they have to tell the big lie.
Erika, understanding that probably all of us here agree that there are, whether it's one or multiple big lies or myths about the litigation finance industry, do you think that critics of third-party funding make any legitimate arguments? Do you think, for example, that there might be some amendments that would improve the overall judicial process? And I'm asking because, as you well know, under some arbitral rules, such as the ICSID rules, disclosure of the funder is required, and the reason for that is so that the appointed arbitrators can avoid a conflict of interest. So it's a procedural rule. And these recent amendments, at least insofar as ICSID is concerned, don't seem to have dampened funder appetite to invest in international arbitration matters. But then again, the requirements are pretty de minimis. The rules don't mandate, for example, disclosure of the terms of the funding agreement. And so I wanted to know what your thoughts are, and you alluded to this previously. Does any amount of regulation make sense?
That's a good question, and I'll take it from the international approach first. I think if we're looking comparatively international versus US, we have to be very cognizant of two things. One, there's at a higher level two different systems, a civil law system and a common law system, right? Civil law systems tend not to have a lot of discovery. You show up to the case with your proofs. That's important, and I'll get to why. In international arbitration as well, we tend to have more limited discovery, although I will tell you, I've been involved in massive arbitrations with terabytes of discovery. The foundational point here, though, is just to compare. If you have a disclosure regime in an environment that is curbing discovery, and it's carefully guarded in terms of protecting against conflict of interest. That's the goal. I think what we have to be asking is, what is the goal, right? Then that can make sense. And for the ICSID, new rule 14.1, there's other rules in terms of SAIC in Singapore. I will say SAIC in Singapore and the CAMC-CBC in Brazil were one of the first two organizations that addressed this topic. Brazil is a civil law jurisdiction, and what we saw with the resolution in 2016, they now have an arbitral rule or a few articles for the CAMC-CBC in their newer rules in the newer iteration in 2022 that provide for actual mandating disclosure. But these efforts in international arbitration toward disclosure were all trying to curb conflicts of interest and trying to protect the overall integrity of the award at the end, trying to minimize anything that would take away from the enforceability and integrity of the award, which would occur with a conflict of interest, right? And then the other aspect was they were all, to your point, you mentioned de minimis, disclosure of the identity, the existence of funding, but there were careful guardrails. We saw some issues that popped up in terms of, security for costs, applications, this, that, and the other. What we have to remember, in taking it to the US context, disclosure of the funding agreement is a different story from disclosure of the existence of funding. Disclosure of the actual existence of funding, if it stops there in terms of the identity of whoever is involved, that's a discussion point. But what we've seen, and it's important for people to understand, is complete and entire sideshows over this discovery battle, which will eat into the budget. It's just another tactic, sorry. And for those that don't understand it and haven't seen it, what litigation finance does is, frankly, in all the ways that Stuart mentioned, it is very helpful to lawyers and to their clients, but it keeps us on budget. We're approaching our cases with a budget. And when that budget is eaten up by this discovery sideshow that ensues, who's benefiting, right? And so what we have to be very careful about is asking, what is behind what is happening? If it's purely disclosure to know who's involved and to avoid conflicts of interest, that can be done in camera, that can be done on a de minimis level, but we have to question the relevancy and the motivation behind the additional attacks. And in the US, our system is very different in terms of discovery than it is abroad. So when we look to international arbitration and we look to what's being done, we have to be mindful that there's a different lens that is applied internationally versus in the US. We have different legal systems, we have different rules, right? And so that's one of the things that I don't think is often picked up by those that are looking at these these other examples, unless they've practiced internationally. And so it's just an important point. And I'll underscore what Stuart was saying. I've been involved in this industry for a really long time. I negotiate the litigation finance agreements, and there are protocols and mechanisms by which we have to operate. And with a careful review of these agreements, for instance, if control is not remaining with the client, that subjects and opens up the funding agreement to an attack on the ultimate enforceability, right? There's other guardrails that are already in place. And so understanding what's really taking place from the whole lifespan, and that's, again, you've had the gateway function, you have sophisticated parties that are negotiating with lawyers, and then you get to the resolution with this agreement. And this is a long-term relationship, and so I think that there's this aspect where people don't fully realize how much is involved and how long it takes to get from the idea of potentially using litigation finance to the execution of agreement to then the end or resolution of that dispute. That's a long time, and it's a lot of effort. So, I think people think magically there's this pool of cash. Who wants it? That's not what's happening at all.
I'd like to pick up on Erika's mention of conflict of interest, because I've had this discussion in particular with a federal judge who is sort of unilaterally making the rules in his court and his whole district about whether there should be disclosure of litigation finance. And I asked, what is your goal? What are you trying to do here? And he responded, avoid conflicts of interest. I said, okay, so to avoid conflict of interest, you need to know who the funder is. I said, let me just ask you personally in your portfolio and your wealth, are you invested in a whole lot of litigation funders? I said, because we don't take retail money. We take large institutional money. And so I'm not sure where this conflict comes about, as if, I think we saw a case where a judge's wife owned Boeing shares and Boeing was the defendant, and there was a judgment and it was reversed and remanded and said, you needed to disclose this conflict and step aside. But you, judge, as an individual, can't invest in, sort of litigation finance. Nobody's taking your money unless you have, 25 million or something to that. And to which he laughed and said, no, that's not quite what a judge's salary is. So I said, well, then tell me how this comes up. I said, do you ask who the insurance carriers who are involved? Because most of them are public. And it's actually possible that you own them, but you don't ask about them, but you want to know who the litigation funder is. I said, so just from a practical standpoint, tell me how you can do that. I said, on top of which, if there's not disclosure made as to whether there's funding or not, then what is the conflict of interest? Because you don't have the information to say I am or am not invested, and there's no way for you to find out because you can't look in your brokerage account and say, oh, do I have any benchmark advisors? Because we're not public. Now there are a couple of public litigation funders, and I suggest that be on the restricted list for those judges. You want to avoid conflict? You can have a rule that says you got to disclose that, or I can have the good sense as a judge to say, gee, probably shouldn't be invested in litigation funders, probably shouldn't be invested in insurance companies, probably shouldn't be invested in, folks who are going to come up in front of me in court all the time. And that would be a much better way of handling that conflict. So I don't even see conflict of interest as a reasonable rationale for requiring disclosure. Now, I will say that when I have clients or counterparties who we are funding said, do you mind if I disclose that this is being funded? Sometimes I think that actually can push a case to resolution by saying, look, two things. Number one, we're funded. So if you think you're going to be able to have a scorched earth and just beat us by doing that, you're not. And number two, let me just tell you that this funding gets more expensive as we go along. And so there may be a number that we can settle at in the first year, after there's a little disclosure going on. But if you wait till year 3 or 4, we can't get to that number anymore because what we're going to owe the litigation funder is just too much. So maybe an early resolution would help everyone. So I'm okay with that. And I don't think we ever turned anyone down from disclosing that they have funding. And sometimes at mediations, I actually suggest that they disclose it. But does that mean it should be mandated? Again, as Erika keeps bringing up, for what end? And until we come up with a legitimate answer to the question, for what end, it's really hard to have that discussion.
Yeah, and if I can, I just want to underscore the proportionality aspect that Stuart mentioned. I think it's really important to keep in mind proportionality. The corporate disclosure rules under the Federal Rules of Civil Procedure peg the limit at 10% before you have to disclose. So not only Stuart's point in terms of the likelihood that a judge may or may not have invested in a public litigation finance company or the like, which is probably not a good idea anyway, but at what level of an investment is it rising to a 10%? How much have they invested as it relates to this particular matter or the like? So it's just, and on the insurance piece as well, and that's a topic for another tea. So I'll just make a high level remark that
one we probably won't be having.
Yeah, probably not.
I said.
No, but I think it's important to have proportionality, right? I think in respect, and I wasn't going to say anything more than just, we need to be looking at what is actually being done and why. What's the focus? What's really the benefit? And I think just as we've seen, and it's been elucidated by this conversation, when you start to dig a little bit and you start to unpack the quote unquote big lies, you start to see that there's nothing underneath in the sense of what's been politicized and misinformed. So, again, thank you for the opportunity to be able to discuss and highlight what's really occurring and taking place. And this is all part of a broader conversation. But I think the careful and important message here to convey is we can't just allow people to blindly accept the lies that are being told, right?
Mm-hmm.
Ask some questions, try to understand it a little better. So thank you again.
Sure. I just want to bring up one point because I think it's important given that our podcast is geared more towards international arbitration. But I do think the disclosure and the conflict of interest is different in an international arbitration setting than it is in a domestic court.
Yes.
And so, while I appreciate what Stuart was saying, and I think it does make a lot more sense in the context of, a judge sitting in Delaware, for example, I think it is different in the international arbitration context where you have arbitrators who wear multiple hats and are both lawyers and arbitrators. So
yeah, and to follow up on that, I think the environment is different now in disputes funding or litigation funding, but even 10, 15 years ago in investment arbitration, and both Nicole and I have represented our fair share of sovereign clients in investment arbitrations. One of the biggest concerns of states, and I mean capital S state or countries, in investment arbitrations was what would happen if the claimant lost and there's an award of costs and attorney's fees against the claimant. And when things were kind of just maybe in their initial phase in international investment arbitrations, there were a number of funders that did not have some sort of provision in their funding agreements that would allow for the funding of an award against the claimant. And that was rather worrisome to states. And, certainly I was involved in at least a couple of those investment arbitrations where it was quite clear that the claimant itself would not be able to pay for an award against what the tribunal essentially in the end did hold was a relatively frivolous claim.
Skylar, that's a fair question. So then the issue, now we're not talking about conflicts of interest. The question is funding for adverse costs. So now you push that back on the plaintiff or the claimant and say, we're concerned about adverse costs. What are you going to do? Now the claimant has basically three choices to number one and say, I'm sufficiently solvent. Either here's my, financial statements or I'll put up a bond. Or the claimant can say, you know what, I'm going to go find a adverse cost insurance carrier and I'm going to have them put up a bond. Or the claimant can say, I have litigation funding. I'm going to show you that they're able to cover any kind of adverse costs. So now you're dealing with a real problem, adverse costs and protection for adverse costs, and you are offering the claimant an opportunity, the whole panoply, maybe there are other things besides what I've come up with, to address that specific issue. That doesn't regulate litigation funding. That says you have an obligation to show that you can pay, adverse costs. You go do it.
Right, which is absolutely true. And that's something that doesn't come up, I think, as often in U.S. litigation for sure. It does come up much more often in the context of international arbitration, where I do believe it is at least comparatively more common to find adverse costs rulings. And, I have chased after a number of claimants for adverse costs awards.
It comes up in the UK all of the time.
Yeah, I was going to say.
Because they have adverse costs. So we're used to dealing with that.
Plug for ATE insurance.
Yeah. And so we may decide to self-identify and say we're funding. Usually the other side says, yeah, well, we don't really care about that anyway. We still want to see an ATE policy. But again, what you're given there is not we're forcing you to disclose. We're forcing you to take on and show how you are going to honor an obligation that you have. And I have no issue with that.
Yeah. Agreed. I think in that respect too, there's a solution for that problem. And it maybe took a little time to figure it out, but that problem, is addressed as you've described, right? As Stuart's described. And that shouldn't occur otherwise. There should be a mechanism by which there's protection against that. I think the harder part too with the investor state arbitrations was traditionally litigation finance supports the claimant. And so the states and sovereigns were on the defensive end usually. And that also was tricky. Unless they had some incredible counterclaim, there really wasn't an aptitude, right, or an appetite for litigation finance. And so it felt even more unbalanced. I remember being in those discussions a lot. And they're similar and analogous to the discussions we see where people are asking, well, is there defense side funding? I mean, unless again, there's a very sizable counterclaim, because why? It's an investment. You need some sort of recovery in order to justify said investment. And that's the problem. And I think from the sovereign's perspective, that was difficult, probably. I mean, again, and I think those mechanisms in place to make sure that these claims were meritorious, whether there was an adverse cost regime, ATE insurance, security for costs, I think those were important because there were a lot of resources that were going to be expended. And the states and sovereigns wouldn't necessarily be able to avail themselves of litigation finance, right? And then on the other hand, you have investors who had lost their investments and didn't have a mechanism, assuming it was a meritorious claim, to pursue that. So I've analyzed it from both sides. I'm very sensitive to the issues from the sovereigns. I understand, but that's sort of the best that we can do, right?
Yeah, no, I absolutely agreed. But the big issue in investment arbitration is that by and large, I would say the majority of investment treaties, if not nearly 100% of investment treaties, don't allow for counterclaims by the states. This is actually an area that is just beginning to percolate in international investment arbitration, where we have now a few rulings or awards by investment arbitration tribunals signaling that maybe states can bring counterclaims in very narrow circumstances. Perhaps that's about where we are there.
It's a long road, and it's tricky. I hear you.
Right, exactly. So that option doesn't really exist for states. So that sort of imbalance still exists. And don't get me wrong, when I was talking about funding 10, 15 years ago and what one does with adverse costs, I think the funding industry has become more sophisticated, as have counsel representing states to this issue. Just as maybe 10, 15 years ago, I would say that there were some international arbitration cases financed through funders who did not necessarily do a ton of due diligence. Or, if that had been the case, then I don't think that you would have found a number of international arbitration awards awarding adverse costs against the claimant. But I do think that now, today, if I'm representing a sovereign and I see that the claimant's case is being funded, I actually do have some assurance that this isn't a completely frivolous claim, because I do know, I do understand the incentives of the funder, and why would they ever fund a case that is, just really not meritorious, unless it is that the funder just doesn't quite understand the ins and outs of that sort of arbitration, perhaps. But in any event, yeah, I do think that the industry has developed quite a bit over the past 10, 15 years, to the point where these sorts of concerns have essentially been ironed out. And if people have concerns, it may be that they're thinking about concerns that existed 10, 15 years ago.
Yeah, I think there's still an educational aspect to this, right? For us, 10 to 15 years, we've learned, we've evolved using the products and the tools, but there are still some who haven't. And so there's going to be a disconnect between the appreciation and understanding. But as someone who's diligenced, I've worked on the investment treaty case, I've diligenced a number of those cases, I'll say there are a number of them that I say no to more than I say yes to. right? And I'm sure most of the people that are doing similar work will do the same and say the same. And so, listen, it's just not a good investment. And I will tell you this, there are newer entrants to the market, but they're still investors and they're still being advised and they're doing their diligence and or their asset valuation, so to speak. And I would assume that it's being done carefully, right? And I want to just circle back to something Stuart said. One of the things, and it's not as much in the investor state context, just more broadly for international arbitration, but one of the things that we've noticed is when the existence of funding has been disclosed just between the parties in whatever way, it has led to settlement more traditionally and more easily in a civil law jurisdiction because there hasn't been a discovery sideshow. But it's been a signaling of this is a solid case that's been looked at, right? Analyzed, studied, and we're still here, and we're here, and we're well fueled. So let's have a pragmatic business discussion in terms of what makes sense, right? Because again, the underpinning of international arbitration, the initial sort of origin was to promote international business, to make things more efficient in terms of dispute resolution and get us back to business. I know it's sort of may not be that realistic, but at the end of the day, as advisors, right, I sit as a lawyer who does international arbitration as well as litigation finance transactions and work relating around litigation finance. But at the end of the day, you need to be looking in terms of the goal of your client. What is the goal, right? What is the point? And as much as they love us, I don't think they just want to continue to pay us. They'd rather get back to business. They'd rather resolve the dispute and or whatever the wrong was and move on. But I think that there's so many different perspectives here. And the international front, though, what I think we need to take benefit of, and I will say this for the US listeners, is litigation finance has been around in the international scheme for a really long time. Australia, UK, we've seen the progression. And while we don't have the equivalent of a Lord Justice Jackson report, I wish we did, look at what's been happening globally in this area and in this field. Understand what's taken place. And some of the discourse that we've seen over the years, it's funny, it feels somewhat repetitive now that I'm hearing it in the US because I've heard it for the last 10 to 15 years, right? But we still have to be patient and measured and discuss and explain.
Well, thanks, Erika. And sadly, we are running out of time. But before we go, we always like to ask one last question of our guests, and that is, other than what we've been discussing on this particular episode, what is keeping you up at night these days? I'll start with Stuart.
I would say the dissipation of the rule of law. Without confidence in the rule of law, our industry doesn't work. And there are numerous jurisdictions that we won't invest in because we're not confident in their rule of law. In fact, when you look at the number that we do, it's a very small portion. Maybe it's, 8, 10 countries out of the 200 and some odd countries that exist in the world. And in some of those areas, including the US, I think there is a crack in confidence in the rule of law. And as I said, without that, the industry doesn't work, but frankly, Western society doesn't work. So maybe I'm being kept up, not just because of the industry, but because of even broader implications.
I couldn't agree more. Erika.
Likewise. I think, again, we need to be thinking critically and analytically, not just accepting what's being put out there, right? And I think there are grave concerns in terms of the rule of law. And I find it very disheartening that our rule of law discussions used to point outward, and now we have to look inward as well. I will say these are questions I'm getting asked pretty regularly by international clients. And I'm hopeful that we will be okay, but we're going to have to be careful, right? And I think the international arbitration rubric does help us in some ways, because as long as the arbitral tribunal is composed the right way, the institutions are doing what they need to do, we're hopeful that the enforcements will go as planned and as needed. There's a lot of hope there, right? And to Stuart's point, without rule of law, the whole system collapses. This is much broader than just litigation finance. The system as we know it collapses. And so, I'm watching very carefully to see what's happening in terms of the reciprocal tariffs, right? Seeing whether the constitutionality or lack thereof is upheld by the Supreme Court. We'll see. But it's, the rule of law and interpretation of the law in a way that is sound is really critical. And so I think we need to make sure that we stay on top of that and hope that we weather the current storms.
Yeah. Sound, predictable, stable, words that used to be used to describe the legal system in the United States. And yeah, I think rather unfortunately it's being eroded. So
I would say this, though, just not to leave and end on a sour note. I think every experience that you undertake or go through is an opportunity to learn. And I think practicing a lot in Latin America, I've seen the cycles that have occurred. And I think the best that I can leave us with is this is a really good opportunity for the US to understand what other jurisdictions have gone through and that it's not always easy. And I think it allows us to be a little more sensitive to what we see transpiring or having taken place in other jurisdictions. I'll leave it at that, but I just think that there's been the side benefit there's been a camaraderie and an understanding and a collegiality in a different way. And so, again, I hope that everything, we'll leave it at that. But I just not to leave on a negative note. There's always an opportunity to learn and grow.
Glass half full, Erika.
Trying. Some days are much harder than others.
Yeah. Well, I want to thank you, Stuart and Erika, so much. You've been wonderful guests, and thank you to the DC Bar. To check out more of what the DC Bar Communities has to offer, please visit dcbar.org/communities. You have been listening to the Tea on International Arbitration. Watch out for new episodes, and if you like this episode, please tell a friend and subscribe anywhere you get your podcasts.